Welcome to Lexagon Legal Briefing, a social project of Lexagon Practice. Our objective is to educate you on the law. However, this does not serve as legal advice. Consult a legal practitioner before you take any important decision. Thank you. Welcome to Lexagon Legal Briefing. We shall be discussing the employer and employee relationship. This should interest you because no matter your walk of life, you are either an employer or employee. And then you can be both. To give highlights on the subject is Mr. Olumide Babalola. Mr. Babalola, you're welcome to Lexagon Legal Briefing.
Thank you.
Mr. Babalola is a legal practitioner and an author of many legal books. So, Mr. Babalola, the employer-employee relationship has often been defined as master-servant relationship. And in this climb, some have really taken that literally. Please, can you explain to us what is the employer-employee relationship?
Thank you very much. I'm going to approach the question from two perspectives. First is the private employment. The second is the public sector employment. I'm going to agree with whoever literally defines the relationship of master-servant as, employer-employee as master-servant. In the sense that the employer pays, the employer gives instructions, the employer provides job, the employer provides the place of work. The employer, so to speak, controls all the activities of the employee as far as the job is concerned. So in that sense, we could agree that an employer is really a master. But on the flip side, that's the public sector employment. It depends on who the employer is. Most people see their bosses or their supervisors as the employer. But in the true sense of it, it is the government that is the employer. And the government is not a person. The government is a system. The government is a contraption that does not exist in human form. So, but in the public sector, the government does not really, in the strict sense of it, assume the position of a master like we see in the private sector. Because the public sector has several procedures that have to be crossed before the employer or the government can actually wield the big stick. So in the true sense of it, literally or otherwise, I agree that the employer is a master while the employee who is paid is a servant.
Thank you so very much. So literally, practically, for all intents and purpose, or most of them, in a private sector, that phrase is more or less accurate, that it is a master-servant relationship. But the public sector is not as it is in the private sector. Okay, so tell us, how is an employer-employee relationship formed? How do you get into this relationship?
The law contemplates it could be formed by oral agreement, and it could also be done by written agreement. Someone asks you, or you apply to work for someone, either in writing, or the person decides to employ you in writing, states what he's employing you for, how you have to do the job, the hours of work you have to put into the job, the remuneration, what he's going to pay you, and discipline if you misbehave. That's why they say this is it's more apt for private employment. The employer can fire and hire at will. He doesn't like you any longer, provided he conforms and fulfills the terms of the contract signed. So it could be entered orally or in writing, depending on the agreement of both parties.
Okay, that you talked about the terms of a contract. Can you clarify that better, or can you throw more light on that? What are terms? What are the terms that a potential employee or an employer should look out for in a contract of employment?
Basically, terms are just the agreements, are just the understanding that the two parties have. You want to work for me as what? What are your roles? When do you resume? When do you close? What do you earn? How do you do the job? Where do you do the job? If you misbehave, what happens? If you want to leave the job, how do you do it? If you are tired of the job or you want to retire on the job, how do you do it? Just the general understanding, the general principles that guide the relationship of the employer and the employee. It could be in any form. Some people, just in one pager, they give you their letter of employment and it contains the basic terms. Terms are just the conditions of employment. It could be in any form. But basically, there ought to be an understanding of what I'm doing as an employee and what he is doing as an employer, and how all these things will be done.
Okay, thank you. What are the obligations? I would like to state them in clear terms. Like when you enter into a contract of employment, what are the obligations, right? You know, sometimes employees think about their rights in terms of remuneration, and then employers think about their rights per the employee doing the job. But what are the obligations? Can you give us bullet points, like what are the obligations of the employer, what are the obligations of the employee?
Basically, without unnecessarily expanding the obligations, an employer must provide job. One, an employer must pay. Employer must provide the place where the job is to be done. Those are basics. Yeah. An employee, of course, must fulfill the terms of his or her employment. You come to your place of work, you do the work expected of you, and at the end of the month you expect to be paid anyway. Or whenever you agree to be paid. Maybe quarterly, maybe weekly, maybe it's a daily wage or whatever. But basically, an employer provides the job, provides the place of work, and provides remuneration.
Can you give us a scenario of providing work? For instance, I'm employed to as a nurse or as a lawyer in a firm, as a nurse in a hospital, a clinic, or any other medical facility. What do you mean providing work? Because if I'm employed as my terms are that you're employed as a nurse or you're employed as a lawyer, how do I provide work? I mean, you're supposed to come into the place and just work. How do I provide? We're communicating to an audience that may not be as legally savvy as we are. So
that's why we talk about the terms of employment, the conditions. While some are comprehensive enough, they would contain what the employee is expected to do every day he or she comes to work, or per time. Okay, you are employed as an office assistant, you report to so person, and you will be required to do this and any other assignment or duty assigned to you by the employer. So basically, when somebody is being employed, the contract might not in all cases contain all the person's duties, but at least you know the designation.
Yeah.
This is what I'm employed for too. So maybe subsequently they now tell you the other things you need to do. But basically, every employee must understand what he is to do, either based on the contract of employment or subsequent instructions that will come from the employer.
So, can we say that if the employer does not provide work, then it is constructive redundancy or constructive disengagement? Can that be inferred, or does it have to be practical?
Well, every case has to be decided on its own merit. In some cases, the employer does not, by no fault of the employer, does not have any work. Maybe no patronage. Maybe, business is not doing fine. But that does not necessarily mean that the employee will not be paid. The employee is entitled to his or her wages at the end of the month or at the end of the period whenever he or she needs to be paid. Redundancy is another thing under the Labour Act, and there are procedures for going about it. When you want to render an employee redundant, there are procedures so that you can properly meet the person's entitlements and everything is sorted out properly. But if you don't provide job, the employee's expectation at the end of the month is to collect his or her own pay, and it's now the employer's fault to pay.
Okay, so that means that an employer cannot say, because there's no business coming in, so you can see that you need to understand, and then not pay the employee.
That business coming in is not the employee's fault. And since they have an existing contractual understanding that at the end of the month, You are supposed to provide work. If you don't provide the work, it's your own fault. I am available to do the work, and I've been so available for a month or more than that. So for every month I come, I report to work, I get paid. So the fact that job is not provided or work is not provided is not the employee's fault. Rather, it's the employer's fault, and they should bear the brunt.
Wow. Everything seems to be stacked in favor of the employee, or so it seems. But being a human relation or human relationship, there would be conflicts, there will be friction. So what are the dispute resolution mechanisms that can be employed or should be employed to resolve employer-employee relationship challenges?
In most cases, if an employer pays his employee, most likely, if you pay the employee per time, most likely there won't be any dispute. The employee just wants to be paid, and that's fine. But there are times when the employee goes above board. There are times when the employee violates rules. There are times when the employee becomes a liability to the employer. That's when some other issues arise, and the employer sees that, okay, this employee is no longer useful for me, then I want to do away with it. But basically, being an employer and employee are ordinarily supposed to be family members. They work for themselves. They work for some common goal. So they should be able to work together as a family. So if any issue arises, disputes, they should be able to talk to themselves internally. Try to resolve it internally and see how they can. Because, they work for a common goal. But where that fails, then they can resort to court. The National Industrial Court is there, and it's specifically dedicated to labor disputes, labor and trade disputes. That is what they do. So anybody who has an issue, you just go there. That is if it's an issue that cannot be solved internally. But I think ordinarily, if everybody does what is expected of them, they should be able to solve all disputes that come. But in the case they are unable to solve, they approach the courts. Except there's a clause in the contract of employment that precludes them from going to court first. Maybe they are supposed to go through some mediation, some conciliation, or some arbitration, and they have to explore that before they eventually go to court. But every employee should painstakingly read the terms of any employment he is about to enter, to be sure that those terms are not slavish, and to even understand what to do per time.
Thank you so very much. But can you, final words, what would be your advice to potential employer when they're about to take on someone for a job? What would you advise? Sometimes, I think maybe sometimes, the employer actually appears to have the upper hand. But when there are conflict situations, it could disrupt business and cause disaffection. So what's your advice to a potential employer? What do you have to take into consideration? What should you put in place before taking on anyone as an employee?
Irrespective of how small the business is, it could still become a liability to the owner if you don't put some things in place, if you don't consult properly. And I think the way our country is, it's not so difficult, it's not so expensive to do some little consultations here and there. Consult some people. You want to employ people, consult some human resources consultants, consult lawyers to know the clauses to insert and the clauses not to insert, to know the implications of all the clauses, to know the implications of you not doing something when you're supposed to do, especially when it has to do with employing people. I think basically any business owner should be able to engage a consultant, legal consultant, and human resource consultant, so that they can properly advise them. Because I've seen a lot, even for some big companies in Nigeria, I've seen a lot of contract of employment that are so watery, that are so unprotective, even of the employer, not to talk of the employee. And I think this goes both ways. An employee is also, I know people could be so desperate to get jobs, they don't want to painstakingly look at the contract of employment, they don't want to look at the clauses that are slavish. But when you consider what could possibly go wrong, one would take more time to address those issues at the inception before it is too late.
Thank you so very much, Mr. Babalola. It has been a great time of enlightenment Yes, and I'm sure that our audience have gained a lot from this discussion and would put into practice what it is we've learned. I think that, like you said, when people are trying to get jobs, they're a little bit desperate, and then they just sign up for anything, and then they find out that it is more costly to have taken on what you took on. It would have been better to hold on, to put in place adequate protective measures, protection in terms of properly articulated contracts of employment, so protect oneself in the future. It's better to take care of now than to wait for issues to arise and try to resolve them in the middle of the game. Thank you. We look forward to having you again on the program. Thank you very much. We appreciate.
Thank you very much.